that hire me, plaintiffs, to amend their complaint. Give us all of the prior history that they can think of so that we can go back to court before that trial date and amend their complaint to include it. Because when you get to that trial date, you can't discuss other incidents that aren't contained in your complaint. It violates someone's right to due process. It violates the right to know what they're being accused of.
Judge Farber, it's Domestic Violence Day in your court, and people show up. There's a whole courtroom full of people, all right?
That's correct.
How are they greeted? And what are they told? And let's start them through that process.
Well, there's a speech that's given by one of the members of the family division at the outset that tells them that the temporary restraining order is still in effect, probably more important than anything else, so that they can't be talking to each other in the hallways or in the elevators or anywhere else. They're told that once we call the calendar meaning that we're going to call the names of each of the cases to find out who's in court, that they should tell us whether they're looking for an adjournment, whether they want to, if they're the plaintiff, the person who's the alleged victim, if they want to dismiss their domestic violence complaint or they want a hearing, or if they're a defendant, whether they're actually going to admit the act of domestic violence or they want a hearing. So that we find out whether we're really going to have trials on these cases, or they're going to be put off for another date, or they're actually going to be dismissed on that day.
If somebody wants to dismiss a case, what do they have to do?
Before we will dismiss any case, we will ask the plaintiff, again the person that's the alleged victim, to speak to, in our county, Domestic Abuse Services, Inc., which are the people that kind of deal with the victims of domestic violence, so that they understand what their rights are with regard to the dismissal, what things they lose once they do dismiss the case, and what they lose is being able to ever use that incident again as the predicate act for domestic violence.
When you say predicate act, you mean?
The actual incident that had them come in on this occasion is the predicate act. Right. Carmen's referred to the history, but the actual act that they're there for on that occasion, once they dismiss, they can no longer use that. If there's domestic violence in the future, they can use it by way of the history, but they can't use it as the actual incident for which they're getting a new restraining order.
And you as the judge have the, I guess, the duty to either dismiss the restraining order or not.
That's correct. Right? Yes.
And what circumstances would you not?
Very few circumstances. The general theory is that victims of domestic violence, if they're truly victims of domestic violence, are caught in the cycle of domestic violence. And at least we are taught as judges that when a victim wants to dismiss, for us to deny the dismissal is in effect feeding into that cycle and making them a victim again. So if we find that they are voluntarily dismissing, that they're not being coerced by the defendant in some fashion, that they shouldn't be, of course, and that they're doing this of their own free will, we will generally dismiss it. If I find in any given case that it appears to me that the victim has really been abused. I mean, I have somebody sitting in front of me that has the physical signs that they were beaten. I will generally not dismiss there and then. I will bring it back on a subsequent date to at least give that person the time to think about again whether they want a dismissal. But if they come back and they want a dismissal, we will grant a dismissal.
All right. Now, you're at the trial at this point. Somebody's decided to proceed. What's the order of things of the trial?
It's a trial, and whether they're appearing for themselves or they're represented by an attorney, the person who has brought the case, in this case again the victim, goes first. They put on their case. They tell their story. The other side, or the attorney from the other side, when they're done, has a chance to cross-examine them about the information that they've given. They proceed through all their witnesses, and when they're done with their side with examination and cross-examination, then the defendant gets the chance to tell his story or her story with examination and cross-examination.
All right, Carmen, what are the nuances of either prosecuting one of these cases or defending?
Well, one of the things I think most people don't understand is that this is a bench trial. This is a trial that is heard and determined by a superior court judge. This is not a jury trial. You're not going to have a jury of your peers making that determination. Some of the nuances are that because you are being accused of a crime as a defendant, you want to make sure that the plaintiff meets all of the elements of that crime. For example, assault. There are different types of assault, but assaults can be an attempt to cause a bodily injury or causing a bodily injury. You want to make sure that the plaintiff has proven, if she's alleging assault, that there was an injury or that there was an attempt to cause an injury. So one of the nuances from the defendant's perspective is you want to make sure that the plaintiff has proven the elements of the crime that he or she is alleging.
What's the biggest defense that's available? Most common?
I think one of the most common defenses are, in order to commit a crime, you have to have the intention to commit a crime. And what I think we see a lot are typical arguments between spouses, between people that have a dating relationship, and it escalates. And one person may not have the intention to commit a crime. That's a common defense. There are many, but that's probably one of the most common.
Gentlemen, we've just about run out of time. And in the remaining moments, I'd like to ask each of you, what sort of advice, now I know, Judge, you can't give advice because you're a judge, but what would you tell people out there to do if they're facing a domestic violence trial in the Superior Court? What should they be aware of?
Probably the most important thing is, if they're not represented by an attorney, is to understand that Carmen indicated that it's a bench trial, meaning that the judge is the one that hears the evidence and decides both the law and the facts of the case on these cases. And a lot of people don't understand that they're in a real evidential hearing, which means that we're bound by the rules of evidence. And so, for example, a very common mistake that a lot of the pro se, the litigants representing themselves, will do is they'll come in with a police report and try to submit it to the judge, and I can't take it because the police officer's not there.
It's that darn hearsay rule.
That darn hearsay rule.
Right.
So one thing they might really want to think about doing, quite honestly, is getting some legal assistance.
Yeah, and Carmen, over to you. What advice would you can give advice, but what would you say?
I agree wholeheartedly with the judge, and that the number one advice is that you should consult with an attorney. And even if you can't afford an attorney, there are people that volunteer. There are legal services organizations to represent those who can't afford and qualify. But this is a trial, and there are serious consequences for those that are convicted of domestic violence. You may be forever barred from your home.
Right.
You may be forever barred from having any contact. I often am asked, how long does the restraining order last for? If it's a final restraining order, it lasts forever.
Gentlemen, thank you both for being on the show. Very informative, and it's appreciated.
Thanks for having us, Mark.
You've been watching Law Talk Today. My name is Mark Gruber. If you want to see some of these shows, we have a website, lawtalktoday.tv. Go there or tune in next week. Thank you for watching, and good night.